And now we are live. Hello, everyone, and welcome to Legal Lunch and Learn, a live show where we ask a lawyer your questions on a legal topic. My name is Charlie Long, and I'm a paralegal here at Maryland Legal Aid within the Community Lawyering Initiative. Along with me and currently behind the scenes is our amazing production engineer, Alec Chase, without whom none of this would be possible. Last week, Stacey Bensky was here speaking with us about child support and how it relates to garnishments within Social Security benefits and disability benefits. And speaking with us this week is Community Lawyering Initiative attorney Tim Darby, and he's going to be speaking with us about eviction rights and the CDC moratorium, tenant rights, evictions and the CDC moratorium, eviction rights. If you have any questions about this topic, please feel free to put them in the comments down below or send it in a message. Now, no advice here establishes a client-attorney relationship, especially not with me because I'm not a lawyer. I'm just here to get you the information that you need. However, if you do have an immediate legal problem, please contact Maryland Legal Aid by phone at 410-451-2805 or by email at lawyer@mdlab.org. And for those who are in need of captions, this live broadcast will be uploaded to YouTube once we are finished here. And I know everyone's going to ask what's on my shirt. They are Tyrannosaurus Rexes. What's up, Tim? How you doing?
I'm doing well, doing well. How about yourself, Charlie?
Not too bad at all. So I guess we have to kind of just get into it because this CDC moratorium ends July 31st. That's this Saturday.
It does.
And I didn't realize it ended so soon. For some reason, I thought it went until September, but this is gonna courts are gonna be filling up next week with housing eviction things going on. So let's just start with the basics. Can you take us through the process of how evictions happen?
Certainly. So the first thing that happens in an eviction process is a court filing. So a landlord filing an action in the local district court for any kind of landlord-tenant related cause of action, we call it. So that could either be failure to pay rent, breach of lease, tenant holding over, or what we call a wrongful detainer. The landlord files that suit, and then the tenant should receive notice of that lawsuit and a hearing date. At that hearing, the judge adjudicates the issue, and we'll get into the details of how these different kinds of cases are adjudicated by the courts. But if a tenant loses in that court case, then the landlord has to go to the local sheriff's office to schedule an eviction. And then once that sheriff's office gives them a date and time, then and only then can an eviction actually occur. The biggest misnomer that a lot of our clients have is that, a landlord can evict them if they haven't paid their rent just in 30 days by themselves. That's not how it works at all. There needs to be a hearing, there needs to be a court order, and then that order needs to go to the sheriff's office, and then the sheriff's office needs to be present for an eviction. So this is a pretty extensive process. It's not as scary as a lot of landlords try to make it seem, as lightning quick and you got to get out in 2 weeks. That's not how it works.
Right. I think that's very important to note because I think a lot of people think, oh, they miss, a month's rent, they're going to get evicted immediately, the next day after, so it's good to know that this actually has to go through a process. And even though it is kind of a threatening thing to have happen, I don't think it's as threatening. As in the sense that as the landlords kind of make it so intense. Now you mentioned, can you explain what you said? Tenant overholding. Yes, can you explain what that is?
Sure. So a tenant holding over action is when a landlord argues to the court that the tenant is still in the property after the expiration of a lease. Let's say I sign a lease starting January 1st, ending December 31st. I'm still there the following January. Then my landlord can take me to court just to get me out of the property because, my lease expired, it didn't renew, we didn't come to another agreement as far as me staying another year. And so if they want to rent that property out to a different tenant, who has the ability to pay more, or for any other reason outside of, discriminatory actions against protected classes, but any other reason.
Okay. And another, I believe I've heard of wrongful detainer before. That's kind of like when you're, if there's a squatter or something, correct?
Exactly. And it's surprisingly common, especially in the Baltimore metro area, where someone will sign a lease with a landlord that they think owns the property, and then they move in, and turns out that landlord just found a vacant property, found a scam victim, and duped him out at a couple months rent and a security deposit, and then the real owner realizes that there's someone that they don't know in their property, and then and then they can go to court for a wrongful detainer to actually get them out of the property.
Wow, that's kind of scary to think
Yeah.
they could be scammed in that way.
Yeah. There was a big story in the Baltimore Sun about these folks. They call themselves sovereign citizens up in Baltimore County. They believe that the law doesn't apply to them, and they just took over this big multi-million-dollar mansion. It's worth a read.
How very Batman of them. Probably not so much, but
more like the Joker.
I'll definitely take a look at that. It does sound like an interesting read. Have evictions been happening this entire time during COVID, or has the CDC moratorium kind of halted everything?
So evictions have been happening. The term CDC moratorium is kind of a misnomer. It's really a protection against tenants. This entire time, a landlord could file a lawsuit to get a tenant out of the property, but the court shut down for a period of time because of COVID, but they could still be filing these actions. And cases that resulted in a judgment for possession before the pandemic occurred, those evictions could still have occurred at the beginning of the pandemic. And so really the way that the CDC moratorium, as we call it, works is that the tenant signs an affidavit essentially saying that they made under a certain amount of money, that that their household income has substantially decreased. Either they've been laid off from work, their hours or wages were cut, or that they have extraordinary out-of-pocket medical expenses. And they would also have to certify that they've done their best to make partial payments. They understand that rent is due. But if they were to be evicted, they would either become homeless or have to live in unsafe conditions, in close quarters with other people, where they may have a better or a more substantial chance of contracting COVID-19. So that's just something you present to your landlord, you present to the judge, and then that should, give you protection against eviction until the moratorium ends, which is unfortunately later this week.
Later this week, yeah. And so you mentioned that rent has been owed this entire time. When this moratorium ends, is it like theoretically our landlord's going to be like, you need to pay me thousands of dollars right now?
They could. So in the vast majority of circumstances, at least that I've seen, when a landlord sues a tenant for failure to pay rent, it is only for repossession of the property. It is not for a money judgment. That's a separate thing, and the service requirements are different. So if your landlord wants to sue you for the rent money itself, then they have to personally serve you rather than just post something up on your door. There needs to be an actual human being involved handing you that paperwork, or someone in your household. I don't want to get into the weeds of service of process. But they could potentially come after you for that unpaid rent. Yes.
So are there any specific defenses if a landlord decides to file against someone, whether it's for eviction or I guess primarily eviction?
Yeah. So if a landlord does sue a tenant for failure to pay rent or breach of lease, any of those things that we already talked about, there is the CDC defense. And then there's also a defense based off of order made by Governor Larry Hogan a while back. With that, you have to demonstrate that you have suffered a substantial loss of income tied to the pandemic. And that can be through, a termination letter by a former employer, bank statements. Different judges have different standards of what they want to see as far as your demonstration of a substantial loss of income and how that's tied to the pandemic. So, like the CDC order, that is also quickly coming to an end. That's going to be expiring on August 15th. So that is, very unfortunate for a lot of our clients, but that is a defense that's going to last 2 weeks longer. Outside of those two, then we just get back to pre-pandemic tenant defenses. The most common that I've seen is rent escrow, and that's used as a defense in failure to pay rent actions. That is when a tenant says that there is a significant threat to health and safety in the property. And then you can use that as a defense in a failure to pay rent case. And then there is a new case, rent escrow. The failure to pay rent is, paused until the escrow case is resolved. Different jurisdictions handle the process of rent escrow differently, but essentially an inspector comes out, analyzes whether or not there is a substantial threat to the tenant's health and safety, and then reports that back to the court. And then the court has a lot of discretion as far as what it can do. They can order that a rent escrow account be created that a tenant pays into until the landlord actually fixes the problem. So the landlord doesn't get that rent money until they do their job to fix the issue. If it's a very serious threat and the landlord isn't doing anything about it, the court can abate the rent, basically cancel the rent obligation of the tenant. They can end the lease. A lot of things are within the court's discretion in a rent escrow action. Another defense that we oftentimes use for our clients is licensing. In a lot of jurisdictions in the state of Maryland, including Baltimore City, landlords have to be licensed. And so that means an inspector has to go out and see that it is a habitable place for a tenant. So that's always a good tool. Whenever I have a client in a failure to pay rent action, I always check to see whether or not the property is licensed. And then there's just the simple matter of disputing how much is owed. If a tenant thinks that they're current, they should absolutely keep receipts, and the landlord has the burden of showing what we call their ledger, basically an accounting of what's due, what's been paid, the whole rundown of the financial circumstances. So you can dispute how much is actually owed because of prior payment and prior obligation.
Now, I know Tim just offered a lot of information. So if you have any questions about anything, please feel free to put it in the comments, send it in a direct message. Also, if you need to just rewind to catch up on all of that, like I said earlier, it will be uploaded to YouTube. Speaking of questions, we had one come in from Facebook. If a tenant has a lease and the landlord dies, does that nullify the lease? Can the landlord's heirs evict the tenant?
So that's a good question. When a landlord dies, it would be the estate of the landlord that becomes the new landlord. So after a person passes away, an estate is the legal mechanism or the legal representative of that individual. So it's kind of a legal fiction, and it's difficult to really describe beyond that. But essentially, yes, the heirs would eventually become the new landlords if the lease is still, in effect, but it would be the estate that would be the landlord.
Okay.
And the heirs would have the right to, those rent proceeds. However, the landlord's will is constructed, or their family situation, if they died without a will.
Right. Okay. So I know we've been talking a lot about like a sort of state and local level, because that's where evictions usually that process happens. But we do know that the president is helping some people who can't pay their rent. Is it possible to get assistance? How likely is it to get that sort of federal assistance, if any at all?
Yeah, so it really depends on where you live. So money has been made available to counties throughout the state, throughout the country, local jurisdictions and cities, but every jurisdiction is handling it differently. So check with your local county or city government. If you have any questions, give us a call. There is assistance out there for folks who are behind on their rent because of the pandemic. But that money may be out in some jurisdictions. It may still be available. It really all depends where you live.
Okay, cool. So I believe we talked about rent escrow, and you said there needs to be, like, if there's a serious problem in the housing unit, there has to be like a huge threat to health and safety.
So
And it's just it's just subjective to like analysis, correct?
it's very subjective. It depends on who is in the property and honestly the inspector and the judge. An example I like to give is if I am a tenant in a building with chipping lead paint. If I'm by myself, I'm an adult. I'm not about to go lick the walls. So that chipping lead paint is not as big a threat to me as if I had an infant. They may very well ingest that hazardous lead paint, and that could be a huge issue. So the inspector and the court should take that into account. But otherwise, we're talking about honestly pretty extreme threats to health and safety, like no heat in the winter.
Of course, yeah.
If there's an issue with the roof, we see a lot of the time in Baltimore City, the roof has, open air access. And so like if it rains, then it rains on the top floor. That's the kind of stuff we're talking about. If the front door doesn't work.
Right. Okay.
So it's not as far as, there's what's a good example I want to use. It's not like there's a hole in the wall where there shouldn't be a hole in the wall. It's ugly unless that hole in the wall actually connects you to the outside world. If it's an exterior wall, that's one thing. If it's between two rooms, that's not a situation where rent escrow is appropriate.
You can use that there. Okay. If it is subjective and very dependent on your safety or health, then that does make sense. We had another question come in from Facebook. I have a client that lives in LITC property. I'm not sure what that means to you.
LIT, low income. I should know. Off the top of my head, no, I don't.
They have a client that lives in LITC property. Although their income has increased, how much should a client be charged? My client's rent was $610. The company claims that the market value is $1188 in Caroline County, Maryland.
Gotcha. I truly don't know off the top of my head. I'm sure there's a formula for that kind of assistance for low income tenants. I'd be happy to talk about that offline, but off the top of my head, I don't know.
Okay. Well, we'll figure that question out later and get in touch with this person after the lunch and learn. But what should a tenant do if the landlord doesn't return their security deposit? They did mention that it's low income tax credit, by the way.
Yeah, low income tax. Okay. So if a landlord doesn't return a security deposit, the first thing that a tenant should do before they leave is to do a walkthrough with their landlord. And that's just to document any kind of damage so that everybody's on the same page as far as what's been damaged, what can be taken out of the security deposit, and why. If that doesn't happen, then after 45 days, the landlord is obligated to send either the security deposit back or an itemized list of deductions from the security deposit showing, how much was deducted and why. So if it was, bathtub reglazing, it should say that $200 and so on and so forth. So if the landlord doesn't do that within 45 days, or if the tenant disagrees with what was deducted, then they can sue for their security deposit back. And if it was wrongfully withheld, then they can ask for 3 times that security deposit amount in an award from the court. What is important to note in a security deposit context is what we call normal wear and tear. It is expected that after tenants live in a property for a certain amount of time, then there would be, certain damage to the property, just as a matter of course of people living there. And that shouldn't be taken out of a security deposit. So like a scuff on the wall here and there, thumbtack holes, that kind of thing. That's normal wear and tear. Right. It's kind of the difference between a scuff on the wall and a hole in the wall. So landlord, they should be able to keep whatever money they needed to pay someone to fix that hole in the wall from a security deposit. But as far as, taking the Mr. Clean magic eraser, getting that scuff off the wall, that's not something that should be taken out of a security deposit.
Okay. So normal wear and tear is pretty much okay. I think a lot of people tend to be very detail oriented when it comes to those things. I remember living in apartments before, and you're moving year to year, so you're like trying to make sure that everything's like the walls are clean, everything's fine. But I guess it should be expected that, oh yeah, the carpet might be browner than it was when you first moved.
And that's actually important that you note that, because almost most leases that I've seen, a lot of leases that I've seen actually have requirements for professional carpet cleaning to be done. So, if that's not done, even if it is a little bit browner, or even if it's perfectly clean, then they can deduct from your security deposit for failing to do that if they have to do that themselves. But, I am like you. I am very detail oriented whenever I leave an apartment, just because honestly, a deep clean of the place is a lot easier than going to court. So
it's very
if
true.
you can get out ahead of it, and then do that walkthrough with the landlord, that's really the best situation for everybody involved.
And in that sort of sense, you should probably be doing a walkthrough with the landlord beforehand to like note anything that might be wrong in the place as well, right? If you haven't done one already, which I'm assuming you would have, but maybe one that's specifically for that, to say, hey, this is this, or taking pictures of it, right?
Absolutely. Anytime you move into a new place, you should make an itemized list of anything that, could be considered defective in the property. So if there's a scuff on the wall here, if there's, a little bit of mold in the corner of the bathroom there, definitely keep a list, take pictures. The last time I moved out of a rental unit, I just took a video walking through the entire place just to demonstrate what was there the day that I moved out. And luckily, I got my whole security deposit back. They did try to take some out, but then I had that video, so it was okay.
It's good. Yeah, I think that's definitely good advice. It just helps you keep ahead of having to go to court, or maybe missing out on some money that should rightfully be yours.
Absolutely.
Another question coming in from Facebook: are landlord legal fees deductible from security deposits?
Landlord legal fees deductible. I would have to check on that. I guess it would depend on the context. Why are they hiring an attorney? Like for a breach of lease or a failure to pay rent? I should know that off the top of my head. I don't. I would have to check on that.
Okay. And come back to that.
Yeah.
I know we did talk about one scam earlier. Are there any other landlord scams that people should be watching about? Something that they could check beforehand, just to like make sure they're securely doing it with the right person or anything?
Yeah. So just going back to that fake landlord scam, one way that a tenant can protect themselves is to check on the State Department of Assessment and Taxation website. We call that SDAT. You can look up any address in the state of Maryland and see the legal owner of that property. So if you're dealing with, Mike Jones, who says he's the landlord, and SDAT says the owner is Mike Smith, then you better ask Mike Jones, what's the deal? Where's Mike Smith? I want to talk to Mike Smith.
Cool. So there is an easy way. This is pretty much like a public records kind of thing. You can just check to see, make sure everything's cool, copacetic with the
Absolutely.
landlord, so you're not giving your money away to someone who actually doesn't own the property.
Absolutely. And, with the example of the two individuals, landlords oftentimes have agents who work for them, especially, corporate landlords. So even if you're dealing with one individual, they could be working for the owner. And if the owner is a corporation, they could have a property management company that serves as their agent. So you just want something that ties back the person that you're talking to with the legal owner of the property.
Okay. Wise words, good things to look out for. Um, I think like a lot of this comes down to just making sure you're doing your homework. If you are suspicious, making sure you're protecting yourself, covering your own assets when you're moving in or moving out of a rental place. Um, Another Facebook question coming in a FTPR case, can the landlord keep the security deposit to offset the delinquent rent?
Yes. I again, this is one of my 95% sure. I would want to check on that just to be sure. But having not actually seen that situation happen, easy check, but I am very much leaning yes, but I don't want to say that 100%.
Okay. So we're 95% yes on that. They can. Uh, there's a large possibility that the landlord can keep the security deposit to offset delinquent rent. And I mean, I guess, to round out this whole conversation, um, like what is overall one of the most important things you can think of about evictions?
Just that there's that court process. Don't let your landlord scare you, make you think that you got to be out, before you have a hearing or any court case is filed. Um, if a landlord does try to evict you themselves without a court order, without the sheriff's office, that's actually what we call a self-help eviction. And you can actually sue them for damages for that. And in Baltimore City, it's actually a crime. So you can go to the commissioner's office and, try to have criminal charges filed against that landlord. Um, just, take the eviction process very seriously, but know, you may very well have defenses. Always talk to a lawyer, just because there may be a defense in your situation that you might not know about. But just know that there is that process, and that you may very well have those defenses, and just, we want to help as best we can.
Right. I think, yes, that's very important to know. And one of the things that I've learned um, throughout being at Maryland Legal Aid, that especially during this pandemic, is that no one can just knock on your door and say, hey, you're evicted, get out right now.
Mhm.
There is the entire process that you have to go through. You do have to have, like you said, the notice from the sheriff, just kind of reiterating everything you say. So I think everyone should be aware of that. Like, they can't just make you leave. You do have protections, you do have rights, and there is an entire legal process that they should be going through. So
Absolutely. And
def-
it's beyond a notice from the sheriff. The sheriff has to be there, or, deputies of the sheriff's department. So it goes beyond that. They actually
so
have
they
to.
actually have to show up.
Correct.
An officer of the law of some sort has to show up at your residence and do they
Correct.
physically hand you the notice, or
So you should have received the notice beforehand,
okay,
that they would be coming on X date at X time. Um, so again, different jurisdictions handle the finer details differently, but you should have gotten that notice beforehand. The sheriff's deputy or whomever, they just have to be present at that day and time for the
okay,
event.
okay? That's, like I said, more good information to know, because I know that there are a lot of low income families or low people who are in low income housing who they don't have access to this information. So they think that, when you're evicted, it's right then and there, you're out. So I think this has been extremely helpful overall, especially considering that, like we all know, the moratorium that we think has been all encompassing and very protective is coming to an end on the 31st. So rent has been owed this entire time.
It has. It has.
As you know, the pandemic has done us all in for and taken us for all of us for quite the loop.
Yeah.
So be looking out for those things. Like you said, if you have any questions, please get in touch with a lawyer about anything concerned with evictions, tenant rights, all those things that you may need in the coming months. Thank you, Tim, for joining us, coming on to Legal Lunch and Learn this week and talking to us about eviction rights. It has been very knowledgeable, very great to have you here. I don't believe we have any more questions coming in. So in that case, we will be signing off. We will be taking a short hiatus from Legal Lunch and Learn while we figure out more topics to come to you and speak with you about. If you have anything you want to know about, please put them in the Facebook messages or the comments for this video. Again, this video will be uploaded onto YouTube if you need more instructions. All right. Thanks, Tim. Thanks, Alec. Thank you, everyone, for watching. Bye.
Thanks for having me. Take care.